Good morning, everyone, and apologize for being late. I had to make my way around a fresh fender bender. I think some of the teenagers haven't been driving very long, and school is in. So, anyway, my name is Felicia Orth, hearing officer appointed by the Cabinet Secretary to conduct a hearing in DWB 24-13. This is a compliance order appeal, compliance order involving the Water Protection Division, Drinking Water Bureau, and Camino Real Regional Utility Authority. We will probably just be referring to the division as the division and the bureau as the bureau, and Camino Real as CRRUA. I've heard that acronym. The action has been going on now for about, I want to say, a year and a half. I've walked through all of the prior pleadings, although I was not the original hearing officer, and I'm aware of the stipulated partial final order limiting the scope of this week's hearing to the calculation of penalties, and also, let's see, the order of proceeding that was entered by the prior hearing officer, Mr. Virtue, explaining the process we will step through, the order of presentation. The hearing will be conducted generally in accordance with 20.1.5 of the New Mexico Administrative Code. Those are the department's adjudicatory procedures. And of course, the action was brought under the Environmental Improvement Act and the Drinking Water Bureau regulations. The hearing is being recorded and transcribed by Kim Schollenbarger, Maricopa Reporting. Please contact Ms. Schollenbarger for a copy of the transcript. We're being supported here by Luis Lopez from the Office of Public Facilitation, and Pamela Jones is on the platform to assist from there. If I could please have appearances. Let me start over here. Mr. Real.
Good morning, Madam Hearing Officer. Marcus Ryan, Jessica Nixon, Robus Ryan, and Anaya, on behalf of the complainant, the New Mexico Environment Department, Water Protection Division, Drinking Water Bureau.
Thank you very much. Ms. Carey?
I'm Susan Carey with the law firm of Utton and Carey, representing CRRUA, and my co-counsel is Adon Trujillo.
Hello. It's my first time meeting several of the council here. So I will, one of the elements of this hearing is public comment, and in an earlier procedural order, the hearing officer stated that public comment would be invited at 1 p.m. Each day after the end of the lunch hour. That's my memory. Yes, okay. And then again at the end of the technical case, just as a kind of wrap up. So we will take a lunch break today with time to come back and accept public comment if there's any to be given. If there's anyone on the platform or in the room who would like to offer public comment and has a time constraint such that you would like special consideration, please see Luis on a break and tell him about that, and we will do our best to accommodate you. You can also always hand Luis a written public comment, and it'll become part of the record as though you spoke it. All testimony is taken under oath and is subject to cross-examination, although I discourage cross-examination of public commenters. No decisions will be made this week. What we're doing is making an evidentiary record. After the evidentiary record, we get the transcript. After the transcript, the parties have an opportunity to submit post-hearing submittals with written closing argument, proposed findings of fact, conclusions of law. I write a hearing officer report. The parties, I believe, are given an opportunity to comment on that report, and then the cabinet secretary makes a final decision. So it's not a short process. Let's see here. Are there, well, actually, before I ask for stipulated exhibits, let me ask Luis, did the VPN ever come up at the Environment Department such that we had those orders on the dispositive motions?
I believe it did this morning. So the cabinet secretary has not signed the orders yet.
Okay, so I am sorry about yesterday. The department internet was down entirely. And if I'd known that that was going to not be a short outage, I would have just talked about the dispositive motions. So let me just address them briefly right now, not trying to be mysterious. On the motion to dismiss, which asserted that the department had to choose between an administrative enforcement action or an action in court. I have been doing administrative law for almost 40 years in New Mexico and knew that somewhere, I thought maybe it was in the Statutory Construction Act, what is that, Chapter 12 or Chapter 14, that or included and or. I knew that was somewhere. And it's not in the Statutory Construction Act, and I didn't find case law quickly, but I found it in the Legislative Drafting Manual that's published by the Legislative Service here, that or includes and or. I also found that or has been kind of open to two different constructions according to a variety of dictionaries and media for a very long time. So that was why the motion to dismiss was the motion for summary judgment was spent a lot of time there, and I did understand the expectations of the respondent that what would come back from the complainant was, for example, affidavits, a real fleshing out of the dispute, a real sharpening of the dispute, and a sharing of the facts that would indicate summary judgment should not be granted. At the same time, their response was due 2 weeks before hearing. Again, all of these deadlines were set by the prior hearing officer. What had been time for argument on the dispositive motions had vanished from that final procedural order. And the more I reflected on it, the more it seemed apparent to me that although the arguments weren't clearly without merit, I could imagine arguments on the other side that wouldn't be without merit, and that rather than spending a lot of time exploring the merits of the arguments and what evidence could come in on the motion, that we were right here at the door, at the threshold of the hearing. And the appellate courts have been telling the Environment Department for a long time they prefer the Environment Department to make an evidentiary record. So I thought our time would be better spent making that record, inviting you to make the arguments you made, and the department to make its arguments, than to continue the hearing another time. It had already been continued a few times. And exploring a dispositive motion rather than making a record. That was the motion for summary judgment. So you'll get them. They're short orders. It'll be anticlimactic by the time you get them. I couldn't share them without the department VPN being up. So I was handed the exhibit book and the exhibit folder from each party. Are these stipulated, or should we walk through each of them to address stipulations?
Madam Hearing Officer, we attempted to get CRRUA to stipulate to the exhibits. Mr. Trujillo felt like he has objections to the exhibits and therefore wants to, I think, read his objections into the record as we try to introduce each exhibit.
Okay. Let's see. Yeah, we'll just handle objections as we get to them instead of walking through them now. All right. So we would turn next to opening statements unless there is something else.
Yes, Madam Hearing Officer.
Yeah.
Yeah, I do have two preliminary matters. First is a request for clarification, Madam Hearing Officer. So as a preliminary matter, CRRUA respectfully requests clarification on the record as to the orders, which you have provided some clarification on denying CRRUA's motions to dismiss and for partial summary judgment. So at yesterday's short hearing session, I believe the hearing officer made a comment to the effect that you didn't believe you had authority to rule on dispositive motions or something to that effect. And in the interest of not misunderstanding the hearing officer's comment, we'd like to request clarification in light of two specific notions. And the first notion is that, as the hearing officer mentioned, this hearing is governed by Part 20.01.05 of the New Mexico Administrative Code and Section 20.1.5.200 D6 of that part, which deals expressly with motions, does clearly state that all motions shall be decided by the hearing officer without a hearing. And then in addition to that express grant of authority, Section 20.1.5.100 F2 of that same part authorizes the secretary to appoint a hearing officer to perform the functions described in subparagraph B of that subsection. And the functions in subparagraph B provide that, quote, the hearing officer shall exercise all powers and duties prescribed or delegated by the secretary under the act or this part. The hearing officer shall conduct a fair and impartial proceeding, assure that the facts are fully elicited and avoid delay. And the hearing officer shall have authority to take all measures necessary for the maintenance of order and for the efficient, fair, and impartial adjudication of issues arising in proceedings governed by this part, which include but is not limited to authority to 1, rule upon motions, procedure requests, offers of proof, and issue all necessary orders, as well as 2, administer oaths and affirmations, examine witnesses, and admit or exclude evidence. And finally, only Section 20.1.5.103D of this same part expressly contemplates one specific situation where the secretary is solely empowered to rule on a motion, and that situation is limited to, well, any motion seeking disqualification of the hearing officer or the secretary, and the relevant part states that such motion shall be ruled upon by the secretary. So this is the only provision in this entire part that expressly reserves the authority for the secretary to rule upon a motion when a hearing officer has been appointed. CRRUA therefore asserts that you did have the requisite authority under this part to rule upon its motion. And then the second motion is that even in the event that this part contained language to the effect that only the secretary may rule on dispositive motions, which it does not, CRRUA asserts that its motion for partial summary judgment was not fully dispositive. Of course, it did not fully dispose of this case and only sought summary judgment as to one specific aspect of NMED's case. So the authority to rule on CRRUA's motions would clearly appear to fall within the authority that was granted to the hearing officer pursuant to those above cited sections. And so CRRUA therefore respectfully requests clarification on the hearing officer's comment. She was without authority to rule upon CRRUA's motions to dismiss and its motion for partial summary judgment. In addition, lastly, in response to the hearing officer's comment, we'd request clarification that the hearing officer stating that the factors that went into the denial of the CRRUA's motion for partial summary judgment were: one, that NMED did not have sufficient time to formulate an adequate response; two, that appellate courts have presumably instructed NMED through binding precedent to develop an evidentiary record instead of disposing of issues by summary judgment motion. And if so, hearing officer, we would appreciate it if you could guide us to some of those decisions so that we may look into that. Thank you.
All right, so this particular cabinet secretary and I, serving as his hearing officer, had this discussion in a matter. I don't remember the docket number. The name of the case was Medina and Sons. It was an air quality enforcement action. It's probably not on the docketed matters page, might be on the archived docketed matters page. And it is my understanding, not just from this cabinet secretary, but previous cabinet secretaries, and certainly also with the other entities attached to the Environment Department, the Environmental Improvement Board, the Water Quality Control Commission, that the hearing officer reviews dispositive motions, makes a recommendation, right? Offers up her feeling about the dispositive motions, but then that final order, because it's dispositive, is actually signed by the cabinet secretary or the board or the commission. Much of the case law directed to the Environment Department is related to landfills, but sitting here, I don't have citations for you, and I'm not sure that this is a good use of our time. I could develop it further in a hearing officer report, for example, but we have always been had more favorable outcomes in the Court of Appeals and the Supreme Court when we've gone ahead and made a record rather than summarily disposing of things, unless what was being summarily disposed of was nearly frivolous. And nothing that the respondent said was frivolous, nothing that the department said was frivolous. So again, what I came to was a feeling that the time allowed to explore the arguments raised in the motion for partial summary judgment, and I understood it was partial, but I also understand that the scope of this hearing is limited already to the calculation of penalties. And yes, it wasn't that I didn't have time to review the motion or that the cabinet secretary didn't have time to review the motion. That's not what I'm talking about. I'm talking about the time that it would take to further draw out the department on their argument, for example, that single elevated readings, the 12 MGL or the 15 MGL, whatever it was, which do not result in an elevated rolling annual average because of the other numbers involved, still warrants enhancement under the settlement policy. I could have, if we had time to set up a separate oral argument on the dispositive motions, I could have asked them, right? Because they didn't set that out clearly in their response, but I could have drawn that out of them. And then perhaps made a decision, or at least a recommended decision. But again, we were right here at the door to the hearing. The hearing is this week. We got by virtue of the schedule. And yes, we could have continued the setting yet again, but I didn't think that that was a worthwhile thing to do. It was preferable to make a record since we're going to be having these conversations anyway. So, yeah, making a recommendation to the final decision maker. And the final decision maker sometimes renders his decision after the case is entirely done. And in this case, it made sense to get his opinion before we began today. I think that's it.
Thank you, Madam Hearing Officer. Did have one more preliminary matter.
Okay.
And in the interest of doing it now before we do it at one, the CRRUA objects to the inclusion of public comment in this adjudicatory hearing and believes that its inclusion will lead to reversible error. Madam Hearing Officer, Chapter 1, Title 20 of the New Mexico Administrative Code has 6 separate parts, or 6 separate sets of procedures for 6 separate types of public hearings. Both the plain language of those 6 parts, as well as reading them in pari materia, lead to the conclusion that public comment in this hearing is not appropriate. And so the first part in Chapter 1 is Part 20.1.1. It's rulemaking procedures for the Environmental Improvement Board. And this part's express objective includes the encouragement of public participation in public hearings in Section 20.1.1.6. This part contains a definition for participant as any person who participates in a rulemaking proceeding before the board, and Section 20.1.1304A, which is titled Participation by the General Public, expressly states that any member of the general public may testify at the hearing. No prior notification is required. Present non-technical testimony at the hearing. The second part in Chapter 1 is 20.1.2, adjudicatory procedures for the Environmental Improvement Board. And this part also contains a definition, this time for interested participant, as any person other than a party who files an entry of appearance. And Section 20.1.2207B1, which is titled again, Participation by the General Public, expressly states that 1, any member of the general public may testify at the hearing. No prior notification is required. Third part in Chapter 1 is Part 20.1.3, adjudicatory procedures for the Water Quality Control Commission.
Mr. Trujillo, if I could just, I'm sorry, cut this short just a little. I'm very familiar with 20.1.1, point 2, point 3. I do hearings almost every month for the board and for the commission, and actually for the department. So point 3 is their adjudicatory procedures. Part 6 is the rulemaking, and then we have 4 and 5. 4 is the permitting, 5 is the adjudicatory procedures for the department. So is your point that Part 5 does not include expressly a provision for public comment?
Madam Hearing Officer, may I make my objection for the record? And then this is just an objection for the record. We'd like to have a clear record for appeal.
All right.
And so if you wouldn't mind, I'd just make my objection for the record.
Okay.
The third part in Chapter 1 is Part 20.1.3, adjudicatory procedures for the Water Quality Control Commission. In regards to abatement plan hearings and variance hearings in this part, Sections 20.1.317 F1 and 20.1.318D1, both of which are again titled Participation by the General Public, contain identical provisions which both expressly state that 1, any member of the general public may testify at the hearing. And Section 20.1.320B1 states that the hearing officer shall provide a reasonable opportunity for all interested persons to be heard. The fourth part, as Madam Hearing Officer mentioned in Chapter 1, is Part 20.1.4, permit procedures for the Environment Department. This part expressly states that it shall be liberally construed to facilitate participation by members of the public, including those who are not represented by counsel at Section 20.1.4.100B. This part accordingly has requirements that the notice of hearing sets forth how interested persons can enter their appearance or submit general, written, or oral statements And section 20.1.4 300A2 of this part, which is titled Participation, expressly states that, quote, failure to file a timely entry of appearance shall preclude a person from it being a party in the proceeding, but shall not preclude a person from presenting a general written or oral statement or non-technical testimony in the proceeding. Section 20.1.4 300B2 of this same part states that, quote, any person may provide a general written statement or a general oral statement at the hearing. And 20.1.4 400A2D expressly authorizes, quote, all other testimony or oral statement in the order of testimony. I'm going to skip the fifth part in chapter 1, but part 6, 20.1.6, rulemaking procedures for the Water Quality Control Commission. Again, this part's express objective includes the encouragement of public participation in section 20.1.6.6. It includes a definition of this general public and a participant at subsection L and subsection H of 20.1.6.7 and section 20.1.6.204A, again titled Participation by the General Public, again expressly authorizes that any member of the general public may testify at the hearing. This brings us to this part, part 20.1.5, adjudicatory procedures for the Environment Department. This part, as Madam Hearing Officer stated, governs this specific hearing. This part contains the following in its stated objective: to ensure due process for all the parties. At section 20.1.5.6, this part contains no definition for the general public or a participant, and the definition of party is limited to the complainant, to the division, to the respondent, or any person who's permitted to intervene in the hearing pursuant to Rule 1024 of the Rules of Civil Procedure. Contrary to Part 20.1.4, which expressly stated that it was to be liberally construed to facilitate participation by members of the public, including those who are not represented by counsel, this part, Part 5, has no such language, and in fact does not even include the word participation in any of its provisions or titles. Contrary to Part 4, which required that the hearing officer set forth in the notice of hearing how interested persons can enter their appearance or submit general written or oral statements, this part, Part 5, only requires that the notice of hearing be served upon the parties. Finally, and most obviously, contrary to all of the other 5 parts I just cited, which all includes express authorization for the general public to participate in the hearing, this part has no such language to that effect whatsoever. This part is different, Madam Hearing Officer, than all those other parts, and its plain language is clear and unambiguous and does not contemplate or authorize public comment. In the event that you think that there is ambiguity there, Madam Hearing Officer, CRRUA asserts that when you read the 6 parts of Chapter 1 in pari materia, when you read them together, pursuant to well-established rules of construction, you'll see that 5 of them expressly authorize public comment, and 1 of them, the part that governs this hearing, does not. That was intentional, because this part, more than any other part, or more than any of the other parts, is clearly intended to most resemble a court of law, where my clients' due process rights are protected to the maximum extent possible, where the parties are expressly limited to those who would be able to intervene in a court of law, where the witnesses are identified ahead of time, along with the anticipated testimony they are expected to provide, where the right to cross-examine witnesses is afforded, where exhibits are offered into evidence, where official notice may be taken of any matter that may be judicially noticed in the New Mexico courts, where there is no stated authorization for any member of the public to testify. All of those elements are found in this part. This is a true quasi-judicial hearing, and to include public comment will violate my client's due process rights, and we believe will constitute reversible error. We therefore object to its inclusion and request that this hearing proceed without public comment. Thank you for entertaining me, Madam Hearing Officer.
So, Mr. Trujillo,
Yeah.
I'm going to ask you for your response. I just have a question of Mr. Trujillo first. Again, I am stepping into the middle of a flowing stream here as a substitute hearing officer. I can see in the third amended notice of hearing the reference to the times the public comment will be taken. I believe I saw it was in previous notices of hearing and perhaps a procedural order. I'm wondering, did you object to any of those pleadings?
No, Madam Hearing Officer, we're objecting now in the hearing.
Okay. Mr. Ram.
Madam Hearing Officer, in response, the first thing I was going to say is that the order entered on July 22nd, 2025 stated that the hearing was going to be conducted with public notice, and Mr. Trujillo had the opportunity to object anytime between now and then. Secondly, I'm going to say that if they intended for public comment to be excluded from this particular section, they would have drafted it that way. I know that there's going to be an argument as to statutory construction, but most of the case law in the state of New Mexico says that when you want to exclude something from happening, the legislature will draft it and specifically exclude something. The fact that they did not draft it in does not mean that they excluded it. Third, I'd like to talk a little bit about due process. Mr. Trujillo was talking about his client's due process, and he talked a little bit about people who would be able to intervene in this matter. Do the consumers of CRRUA's water system not have standing to intervene in this case, should they so choose? I think the answer would be yes, if they wanted to. In fact, they filed a class action lawsuit against CRRUA for the very issues that are being heard here today. So I think any consumers of CRRUA's water system clearly have standing to be heard in public comment at today's hearing, because they would have standing to intervene, going back to Mr. Trujillo's argument. Another point, Madam Officer, much like yourself, I've been doing administrative law in New Mexico for 23 or 24 years now, and public comment is always allowed in quasi-judicial hearings. Everyone I've done anyway. And section 20.1.5.100B provides that part is to be liberally construed to carry out the purposes of the hearing. And I think allowing public comment specifically from consumers of CRRUA's water system who would clearly have standing to intervene and who are the affected parties in this lawsuit, who the state of New Mexico is trying to protect, the Environment Department is trying to protect, it would be reversible error not to allow them to be heard today, should they decide to have some public comment. And the last point that I have is that they clearly have, consumers of the CRRUA water system clearly would also have standing to be heard in a quasi-judicial hearing, which is the standard. If someone wants to offer testimony in a quasi-judicial hearing, the standard objection is that that person doesn't have standing, i.e. if it's something to do with a neighborhood association. Well, if they don't live in the neighborhood, they don't have standing to raise the objections. But if they do live in the neighborhood, they do have standing to raise the objections. In this case, should any CRRUA consumers come forth with public comment today, they clearly have standing to be heard today, Madam Hearing Officer. That's our response.
All right, so let me address the I word there. I haven't seen in any of the documents filed in this case so far any motion to intervene, and I would definitely be disinclined to grant intervention as a party on the fly here today, now that we've begun the hearing. But I remain inclined to accept non-technical public comment, and I'm trying to think of another case in which I had to draw some boundaries in an enforcement action against a prominent gravel operator in northern New Mexico.
And Madam Hearing Officer, if I real quickly, Mr. Trio said that they would have the ability to intervene, not that they had intervened.
That's incorrect. The rules that are permitted
Would be permitted to intervene. Now, in this case, Madam Hearing Officer, if you're a consumer of CRRUA's water system, you would be permitted to intervene should you so choose. I'm not saying that they have intervened. I just wanted to clarify that.
I'm sorry, the rule states, quote, any person who is permitted
Right.
to intervene.
So they
Not
would
who could be,
Oh,
who
okay.
is.
Okay.
Sorry. We have to speak one at a time because we're making a transcript. Thank you. Again, I am disinclined to allow intervention as a party. Party status is very different from offering public comment. And so far as I'm concerned, we have two parties here, respondent and complainant. So no, I'm not considering intervener status for anyone, even if they were asked for it right now. Public comment, though, is different. And as I'm going through my memory banks here, the only time I had to draw some different lines around someone being a witness versus someone wanting to offer public comment was in an illegal dumping case with a gravel operator in northern New Mexico, when a community member actually saw this company's trucks go behind a hill, illegally dump, and faced with their desire to offer public comment, I said, that's not public comment. You are effectively a witness for the division, for the enforcing division at that point, because the compliance order relied on that eyewitness. So they had to become a sworn witness of the division, and that testimony obviously had to be noticed up. And that was not public comment. I can't think of another case in which public comment during an enforcement proceeding became an issue. So let's do it this way. I'm still going to invite public comment and will address either in my hearing officer report or before that the role that comment would play in the weighing of all of the evidence. But I'm stepping into this proceeding without a prior, with notice in the record. The public comment would be invited and what time it's going to be invited. And apparently there was no objection before today around public comment being invited. So I'm going to invite it, and we can talk about the way it'll be given along with the rest of the record at some point that's not today. But I'd like to get to the witness testimony. Are there any other preliminary matters?
No, Madam Hearing Officer.
All right. So we're going to start with the complainant, Mr. Real, if you would, please.
Your Honor, Ms. Nixon's going to open the case for NMED.
Oh, the opening. I'm sorry. That's right. Opening statement.
Good morning, Madam Hearing Officer. Doing the same thing over and over again and expecting different results does not work. This is why we are here today. CRRUA continues to ignore its compliance obligations and expects that NMED will do nothing about it. This is not and cannot be the case. CRRUA cannot continue to do the same thing and expect different results while repeatedly and intentionally putting the health, safety, and welfare of innocent New Mexico citizens at risk. We are here today on the New Mexico Environment Department, Water Protection Division, Drinking Water Bureau's second amended Administrative Compliance Order and Assessment of Civil Penalty, filed against the Camino Real Regional Utility Authority, which we will reference as CRRUA throughout this public hearing. As you mentioned this morning, on April 23rd, 2025, the parties entered into a stipulated partial final order resolving any dispute regarding the occurrence of the 5 violations of the drinking water regulations which were committed by CRRUA. As a reminder, those 5 violations were: first, CRRUA failed to notify NMED that its arsenic treatment plants had been offline and intentionally bypassed for over a year. Second, CRRUA failed to notify consumers of high pH levels and failed to provide customers with appropriate action in order to protect themselves against waterborne hazards. Next, CRRUA failed to correct significant deficiencies from the 2019 sanitary survey by the time the ACO was filed and within the regulatory time provided. Likewise, CRRUA failed to correct all 58 significant deficiencies from the 2023 sanitary survey. And finally, CRRUA was cited for exceeding the arsenic maximum contaminant level during the first quarter of 2024 with a running annual average concentration of 35 parts per billion, more than 3 times higher than the maximum contaminant level at the industrial park treatment plant. So where does that leave us today? Today, we are here to simply decide the appropriate amount of civil penalties to be assessed for those 5 violations. More specifically, the crux of the dispute is whether NMED properly included a bad faith enhancement of each penalty assessment. You will hear evidence during this public hearing that the bad faith enhancement is appropriate due to a long history of repeated violations concerning the hazardous contaminant of arsenic being distributed to consumers by CRRUA. The evidence will demonstrate a pattern and practice by CRRUA, a pattern and practice of coming into technical compliance, followed by mismanagement, repeated failures to provide required notice, along with the intentional bypass of arsenic treatment plants on numerous occasions. This habit by CRRUA demonstrates ongoing bad faith for which the enhancement should be applied. The evidence will demonstrate that CRRUA repeated this pattern during the course of this enforcement action and after entering the stipulated partial final order. In May of this year, it was brought to the attention of NMED, by the press nonetheless, that CRRUA once again experienced exceedances of the arsenic MCL. It bears emphasis that CRRUA withheld information from NMED's enforcement coordinator, NMED's Drinking Water Bureau chief, and NMED's counsel of record, despite the express instruction in the pending administrative compliance order that such persons should be contacted while concurrent settlement discussions were occurring. To be more specific, despite being under scrutiny by NMED and having entered into the stipulated partial final order, the evidence will show that on April 24th, 2025, CRRUA conducted sampling, which returned results with arsenic levels in water that was being distributed to its consumers, which again exceeded the maximum contaminant levels. Despite receiving those results on April 30th, CRRUA waited 9 days to inform the public through a press release. In that press release, CRRUA's executive director, J.C. Crosby, promised that CRRUA would take immediate action and had lowered the arsenic levels to below the MCL. However, sampling taken on May 6, 2025, 2 weeks after the previous sample, again showed that CRRUA broke its promise to the consumers because arsenic levels continued to exceed the MCL. Again, instead of immediately informing consumers of the continued arsenic exceedances, CRRUA waited 3 days to inform the public about the May 6 sample results. Moreover, in a third test, the quarterly compliance testing by NMED on May 7th, 2025, indicated that not only had CRRUA failed to reduce its arsenic levels, but the amount of arsenic in the water distributed had actually increased and remained above the MCL. These broken promises and the unwillingness to achieve long-term compliance has eroded public trust, left consumers at risk, and left consumers unable to take the necessary precautions to protect themselves from the hazardous substances in their drinking water. You will hear testimony today that NMED has for 15 years tried to work with CRRUA to resolve problems and achieve long-term sustained compliance. You will also hear testimony that despite this approach, and despite the help offered by NMED, CRRUA has repeatedly come into technical compliance when under scrutiny, but then immediately falls out of compliance when not being watched closely by the regulators. You will also hear that when NMED has attempted to take numerous enforcement approaches, such as sending notices of violation, offering assistance with funding, and issuing ACOs, CRRUA historically delays or avoid taking necessary action to timely come into compliance. You will see evidence that CRRUA's violations related to arsenic are recurring. NMED has issued a series of ACOs dating back to 2008 for arsenic exceedances. Yet, those ACOs and reported compliance efforts by CRRUA have never successfully achieved sustained compliance. Instead, CRRUA continues to blatantly disregard its duty to provide safe and reliable drinking water to its consumers. Doing the same thing and expecting different results does not work. NMED has the moral obligation and statutory responsibility to take more extreme enforcement measures, including the application of the bad faith enhancement to its penalties. This is necessary to ensure that CRRUA finally gets the message that failing to protect its consumers through non-compliance with arsenic standards is not acceptable. Anything less than long-term sustained compliance is not acceptable to NMED, nor to the very people that CRRUA serves. There is no question that CRRUA's history of non-compliance demonstrates that CRRUA is a habitual bad actor. For these reasons, at the conclusion of the public hearing, the New Mexico Environment Department Water Protection Division Drinking Water Bureau will request that CRRUA be required to pay civil penalties totaling $252,000. Thank you, Madam Hearing Officer.
Thank you. Mr. Trujillo?
Yes. Morning, Madam Hearing Officer. As Madam Hearing Officer stated, I do think it's important to frame the issues in this hearing. NMED has issued an administrative compliance order in this matter, and it has discrete allegations of violations, as Ms. Nixon mentioned. And in response to those violations, CRRUA was required to complete a schedule of compliance, and the parties, of course, as Madam Hearing Officer stated, have stipulated that this schedule of compliance has been completed. That compliance order assessed a civil penalty. And so NMED is not here to actually assess the civil penalty. That's already taken place. What NMED is here to do is defend its assessment of the civil penalty, and the penalty policy is clear how a penalty is calculated and assessed. You select the initial penalty from the matrix based on the gravity and size components of the specific alleged violation. You add a multiple day component. You evaluate whether the violator acted in good or bad faith, and then you arrive at a final civil penalty. The evidence will show that NMED's term sheet for the calculation of that civil penalty establishes how NMED calculated that civil penalty prior to amending the compliance order on May 23rd, 2025. That term sheet specifically followed the sequence in the penalty policy with one exception. Second amended ACO then specifically alleged that NMED was required to recalculate the civil penalty based on new information from 2025, and it then recalculated the civil penalty to a specific dollar amount. CRRUA asserts that the allegations that it has engaged in bad faith conduct in 2025 are demonstrably false. They are undisputedly false, as Madam Hearing Officer knows by reading the motion for partial summary judgment. CRRUA instead asserts that the evidence is overwhelming, that it has acted in good faith in response to the violations in the administrative compliance order. The evidence will show, which is undisputed, that CRRUA is not in violation. The 5 violations that Ms. Nixon mentioned have been resolved. The long history of CRRUA is something that CRRUA is not here to dispute, but what it is here to dispute is that there are no reasonable allegations of ongoing bad faith. The April 23rd voluntary arsenic test that Ms. Nixon mentioned did not constitute a violation. NMED did not issue a notice of violation. It did not trigger any obligation on the part of CRRUA to notify the public or anyone else. The May 6th voluntary arsenic test did not constitute a violation. NMED did not issue a notice of violation, and it did not trigger any obligation on the part of CRRUA to notify the public or anyone else. The 9-day delay, the 3-day delay are undisputedly agreed by NMED to not have violated any standard whatsoever. The May 7th compliance arsenic test did not constitute a violation. NMED did not issue a violation. It did not trigger any requirement for CRRUA to notify the general public or anyone else. And so if NMED wishes to make this about the past, that flies directly in the face of what the pleadings say, the allegations in their administrative compliance order, which is focused exclusively on the 5 violations and the new conduct. And in response to that new conduct, the evidence will show that since January of 2024, CRRUA has taken, in conjunction with NMED, 99 tests at its arsenic treatment plants, 6 of which have exceeded the arsenic threshold. CRRUA is in compliance with the arsenic standard. CRRUA has worked tirelessly with NMED's local compliance enforcement officers to join the AWOP program to optimize performance in CRRUA on a long-term basis. CRRUA has implemented standard operating procedures approved by NMED, the local compliance office of NMED. I should specify the local compliance office of NMED. Those SOPs have created a procedure that has vastly improved CRRUA's response time. CRRUA has requested and taken multiple trainings through NMED and provided by NMED in order to enhance its effectiveness at providing safe drinking water to its consumers. And so what we're looking at is a speculative argument. We're looking at the past and saying, does this dictate the future? And CRRUA asserts that the evidence will overwhelmingly show that the procedures that it has implemented and the results of those procedures, which have been agreed to by NMED, will overwhelmingly show that CRRUA is not the bad actor that NMED portrays it to be, and that CRRUA is not only in compliance, but CRRUA has put forth the procedures and the operational expertise to be able to provide long-term sustainable results to its customers. Thank you.
Thank you, Mr. Trujillo. Mr. Real, would you like to call your first witness?
Madam Hearing Officer, NMED calls Deputy Cabinet Secretary John Roderick to the stand.
If you would please spell your first and last name and bring that much closer to you. Okay, not going to happen.
Yes, ma'am. I'll speak up. Thank you, Madam Hearing Officer. My name is John, John, Roderick, RHODERICK.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Mr. Ale.
Good morning. Can you please state your name for the record?
John Roderick.
Mr. Roderick, where are you currently employed?
I'm employed at the New Mexico Environment Department as the Deputy Cabinet Secretary of Administration.
How long have you been in that position, Mr. Secretary?
I've been in the position of Deputy Cabinet Secretary since November of 2024.
And how long have you been with the Environment Department, Mr. Secretary?
I've been with the department approximately 18 years, serving as the Water Protection Division Director prior to becoming Deputy Cabinet Secretary.
Thank you. Mr. Secretary, what, in your own words, is the primary purpose of the New Mexico Environment Department?
New Mexico Environment Department's primary purpose is to protect, restore, enhance the environment, and to protect the citizens of the state of New Mexico.
What different areas and missions is the New Mexico Environment Department charged with?
Thank you. So my portfolio on the administrative side includes 4 divisions: the Environmental Protection Division, Environmental Health Division, Resource Protection Division, and the Water Protection Division. Through those 4 divisions, we are charged with oversight and regulation of solid waste, hazardous waste, air quality, radiation hazards, Superfund, and in the Water Protection Division, we cover groundwater, surface water, and drinking water.
Thank you. What is the main job duties of the Drinking Water Bureau?
So New Mexico's Drinking Water Bureau has primacy given to it by the US EPA. That allows us to act on EPA's behalf to oversee and regulate drinking water systems, public drinking water systems across the state.
And so, Mr. Secretary, in your position, you have interacted with CRRUA before, is that correct?
Yes.
So it's my understanding from what you just testified that NMED applies the federal statutes. And are there any local statutes that NMED applies to overseeing CRRUA?
There are state rules, regulations, and statutes. An example of that being the Utility Operator Certification Program that requires public water systems to have the requisite number of certified operators based on the complexity of their system.
Can you describe, Mr. Secretary, the nature of the complaints your office has received as far as CRRUA's operations go?
Yes, we've received ongoing complaints of discolored water. What specifically came to our attention in December of 2023 was a complaint from the public about slimy water. This caused us to initiate an investigation and send a team down to determine what was causing that problem.
And what was causing that problem, Mr. Secretary, to your recollection?
It was determined by the team that a CRRUA employee had replaced a sensor that monitors the pH level of the water, and it was either improperly installed or was not properly calibrated, causing the system to read a very low pH. This triggered the system to drop caustic soda into the water to raise that pH level. Unfortunately, it wasn't low, so this caused it to elevate the pH to a level where if you got it on your skin, it felt slimy.
We'll hear a little bit more about that from your technical staff as we go on. What has your office's position been in the past when you've dealt with CRRUA's violations? When did you first start to understand there may have been a problem at CRRUA?
Madam Hearing Officer, I'm going to object at this point. Cam, I'll go slow. Just for the record, Madam Hearing Officer. CRRUA objects to any testimony regarding past non-compliance and enforcement efforts. This testimony is irrelevant to the propriety or reasonableness of the amount of the civil penalty that NMED has assessed against CRRUA based upon the penalty policy and the specific allegations in the second amended administrative compliance order. That is the only issue before the hearing officer, whether NMED properly and reasonably applied the penalty policy to the underlying violations in assessing the civil penalty. NMED is not here to actually assess a civil penalty that's already taken place. NMED is here to defend its assessment of the civil penalty. And the penalty policy is clear how a penalty is calculated and assessed, as I previously mentioned. Select the initial penalty from the matrix based on the gravity and size components of the specific alleged violation. You add a multiple day component, you evaluate whether the violator acted in good or bad faith, and you arrive at a final civil penalty. And the second amended ACO specifically alleged that NMED was required to recalculate the civil penalty that had already been calculated on the underlying violations in the term sheet. And it was required to recalculate the civil penalty based on new information from 2025. And then it recalculated the civil penalty to a specific dollar amount. The second amended administrative compliance order did not contain a single allegation that past noncompliance and enforcement efforts were a basis for either its initial calculation or its recalculation of the civil penalty. Paragraphs 34 and 35 of the second amended compliance order specifically alleged that the new information learned by NMED required the application of a bad faith enhancement, and that accordingly, NMED had recalculated the civil penalty. The term sheet that had initially calculated the civil penalty made no mention of past noncompliance or enforcement efforts as a basis for the calculation of the civil penalty. NMED therefore needs to demonstrate that the civil penalty it assessed is appropriate and reasonable based on the application of the penalty policy to the underlying violations and the allegations in the second amended ACO, which do not include any mention of past noncompliance and enforcement efforts, but new information. Evidence of past noncompliance and enforcement efforts is therefore not relevant to the civil penalty and should be excluded. But if the hearing officer finds that evidence to be relevant, then the probative value of that evidence is substantially outweighed by unfair prejudice to CRRUA and confusing of the issues in this case, and it should be excluded pursuant to 11-403 of the Rules of Evidence. Section 20.1.5100 F2B requires the hearing officer to conduct a fair and impartial proceeding, which includes the fair and impartial adjudication of issues arising in the proceedings, allowing evidence of past noncompliance or enforcement efforts when NMED never alleged that such evidence ever formed the basis for calculation or recalculation of the civil penalty is unfairly prejudicial to CRRUA. It confuses the issues related to the specifics of the underlying violations and will not result in a fair and impartial adjudication in this matter. But there's another reason that CRRUA finds this to be an unfairly prejudicial addition, Madam Hearing Officer. Any reliance on any previous compliance orders listed by NMED that were issued to entities that are not CRRUA are unfairly prejudicial to CRRUA for the additional reason that the parties here today, CRRUA and NMED, previously bargained for and agreed that CRRUA would have no further liability for those compliance orders. So to include them in this hearing, as NMED intends to do, would break that bargain and deprive CRRUA of the benefits it negotiated and that NMED agreed to. In fact, the 2016 ACO was resolved through a stipulated final order entered in 2016 between CRRUA and NMED. Paragraph 15 of that stipulated final order states that the terms of the SFO, including the payment in the amount specified in paragraph 10 and in the manner prescribed in paragraph 11, and the implementation of corrective actions specified in paragraph 12, constitute full satisfaction from liability for the violations alleged in that 2016 compliance order. In other words, if CRRUA paid its penalty and implemented the required corrective actions, it would achieve full satisfaction from liability for those violations. CRRUA has completed all that was required of it in the 2016 ACO. NMED has not brought a new enforcement action to enforce that stipulated final order. It is complete. As clearly demonstrated by the compliance order in this case is based on allegations regarding non-compliance with sanitary surveys from 2019 and 2023 and violations from 2023 and 2024, not 2016 or anything before 2019. CRRUA should receive the benefit of its bargain. NMED should honor that bargain. Yet NMED now seeks to use that very evidence which was settled and which CRRUA bargained for liability from, and to which NMED agreed as a basis to support an enhanced civil penalty. In other words, to use the evidence of that prior enforcement proceeding against CRRUA to elicit more money from CRRUA. The probative value of that evidence is substantially outweighed by the unfair prejudice to CRRUA, and any attempt to rely on that prior evidence would fly against the face of the SFO, which is a final order that cannot be used to elicit more funds in the form of an enhanced penalty against CRRUA. CRRUA therefore objects and requests the hearing officer find that this evidence is first and foremost irrelevant to these proceedings. But if it is deemed to be relevant by you, Madam Hearing Officer, CRRUA asserts that this evidence is unfairly prejudicial and would confuse the issues. CRRUA therefore respectfully requests that you exclude this testimony pursuant to your authority to do so under section 20.1.5 100F2B4. Thank you, Madam Hearing Officer.
Thank you, Mr. Real, your response.
Madam Hearing Officer, the plain language of the penalty policy says the NMED may expressly consider history of noncompliance in its enforcement actions. Past conduct is relevant to the application of the penalty policy that we're here to discuss today. Old ACOs are relevant to the application of the penalty policy. Specifically, the policy directs the Environment Department to consider the history of noncompliance in order to include a bad faith enhancement. That's expressly written inside in the administrative code. Therefore, the history is relevant to the reasonableness of the bad faith enhancement. And as Mr. Trujillo stated earlier, it's also relevant as to the new information that was received during this enforcement action. But the policy itself, the plain language of the penalty policy, says the NMED may expressly consider a history of noncompliance when calculating its penalty policy, and that goes to the level of calculation you'll hear from later today from Ms. Medina. Thank you, Your Honor.
All right, thank you. The objection is overruled. The department's penalty policies across media really always or almost always include a history of noncompliance, regardless of whether that noncompliance was addressed through a settlement agreement, coming into compliance, paying of a fee. It's not as though it vanishes from the record. And I'm not a jury. I'm actually capable of the kind of discernment that would allow me to disregard things that shouldn't come in or should not be weighed heavily. So I'm not worried about unfair prejudice, Mr. Trujillo. So the objection's overruled. Let's go back to Mr. Roderick.
Mr. Secretary, I'm going to repeat my question. What has your office's position been in the past when you deal with CRRUA getting violations? In other words, when did you first start to understand there may have been a problem at CRRUA?
Well, I think that the department's been aware of problems at CRRUA for probably the last 10 to 15 years due to repeated times of non-compliance, which resulted in some ACOs, which resulted in notices of violation, and the history of CRRUA bringing things into compliance and then falling back out of compliance. Most recently, as I say, we responded to a complaint from a customer of CRRUA's with regard to the slimy water, identified that in fact it was
Objection, hearsay.
I'm sorry. The slimy water. He testified that the complaints
He
came
received
in.
a complaint from a customer of CRRUA.
Yes.
Object to the testimony of hearsay. He's testifying to an out-of-court statement, sir, for the truth of the matter asserted that he did not make or that CRRUA did not make. I mean, it's a third party.
All right. I understand it's a third party. The department often follows up on complaints made to it. That's a lot of other enforcement actions begin the objections overruled. Go ahead, Mr. Roderick.
Thank you. So following that investigation, shortly after, a sanitary survey was conducted. I would believe that was on December 5th and 6th. That survey had been previously scheduled before we received the complaint. During the course of the sanitary survey and in discussions with CRRUA staff, it was brought to NMED's attention that the arsenic treatment systems were offline and had intentionally been taken offline, allegedly waiting for maintenance repair parts. But we were advised that they had been offline for up to a year. The critical issue with that is the fact that there's an obligation on the part of the water utility operators to notify NMED and to notify their customers when the water that's being produced and given to the public is not safe for consumption.
Mr. Secretary, I'm going to take you and ask you to open the notebook there in front of you to exhibit NMED's exhibit number 2. Mr. Secretary, have you received NMED's exhibit number 2 prior to testifying here today?
Yes,
Are you familiar with the document that is marked as NMED's exhibit number 2?
I am.
Are you also familiar with the contents of NMED's exhibit number 2?
I am.
What is NMED's exhibit number 2, Mr. Secretary?
It is an administrative compliance order to Doña County Utilities Border Region, specifically regarding non-compliance with the arsenic level.
When is that dated, Secretary?
This is February 10th, 2009.
And is NMED's exhibit number 2 a true and correct copy of the ACO issued to Doña County Utilities Board Region?
Yeah.
Madam Hearing Officer, I would now like to introduce NMED's exhibit 2 as evidence in this matter.
Yes, Madam Hearing Officer, objection. This exhibit is not relevant pursuant to the prior objection. In addition, this exhibit is not relevant because NMED's exhibit list indicates it will be used to demonstrate CRRUA's knowledge of relevant requirements that led to the underlying notice of violation. CRRUA's knowledge, as well as CRRUA's history of.
Isn't this the
Okay,
same?
may I finish my objection?
Hold on.
Isn't this the
So your original, I'm sorry, Mr. Trio, your objection just now to the testimony was already overruled. Do you have an additional objection
Yes.
to exhibit 2?
Yes. In that the CRRUA's knowledge, to the extent that this exhibit will be used to demonstrate CRRUA's knowledge of the relevant requirements that led to the underlying notice of violation, as well as CRRUA's history of noncompliance. It is important to point out that the parties in this administrative compliance order are NMED and the Doña Ana County Utilities Border Region, not NMED and CRRUA.
Okay. Mr. Rao?
Madam Hearing Officer, this is the same objection you just ruled on a minute ago, that whether or not the prior bad acts were relevant. You overruled Mr. Trujillo. If he's going to object to every one of my exhibits, this is going to be a very, very, very long day. I would ask that we just deal with this now, if we can. I'm going to introduce ACOs related to every one of the 5 entities that now make up what is CRRUA. I assume Mr. Trio will have the same objection. You already ruled that we are allowed to consider prior bad acts and that they are relevant to the application of the penalty policy. And they knew that the conduct at issue was illegal from their prior ACOs. And CRRUA was aware of that, and yet they continued to act in the manner that they did.
All right. So thank you, Mr. Real. Based on the fact that CRRUA is made up of these constituent agencies, which historically were the subject of prior compliance orders, the objection is overruled and Exhibit 2 is admitted.
Thank you, Madam Hearing Officer. Mr. Deputy Secretary, I'm going to going to direct your attention to, Madam Hearing Officer, should I go through this same exercise for all of the exhibits we just talked about? Or can I just assume that those 5 are deemed admitted?
No, we should do that one at a time.
Okay.
Based on Mr. Trujillo's posture. Go ahead and do it now if you'd like.
Thank you, Madam Hearing Officer. Deputy Secretary, I'm going to direct your attention to what has been marked as NMED's Exhibit 3. Have you reviewed NMED's Exhibit 3 prior to testifying here today?
Yes.
Are you familiar with the document that is marked as NMED's Exhibit 3?
Yes.
Are you also familiar with the contents of NMED's Exhibit 3?
Yes.
What is NMED's Exhibit 3, Mr. Secretary?
Exhibit 3 is an administrative compliance order to Santa Ana Teresa Industrial Park dated May 29th, 2008.
And is that a true and correct copy of the ACO issued to Santa Teresa Industrial Park in 2008?
Yes.
Madam Hearing Officer, I'd now like to introduce NMED's Exhibit 3 into evidence in this matter.
Same 2 prior objections.
Thank you. Those are both overruled. Go ahead, Mr. Rea.
Deputy Secretary, what was the ACO marked as NMED's Exhibit number 3 regarding?
Arsenic.
Specifically, what about arsenic, Mr. Secretary?
They exceeded the arsenic levels.
Okay. Is the Santa Teresa Industrial Park still a standalone drinking water system as it was in 2008?
It is not. It was incorporated into CRRUA.
Thank you, Mr. Secretary. Next, I'm going to direct your attention to what has been marked as NMED's Exhibit 4. Have you reviewed NMED's Exhibit 4 prior to testifying here today?
I have.
Are you familiar with the document that is marked as NMED's Exhibit 4?
Yes.
Are you also familiar with the contents of NMED's Exhibit 4?
Yes.
What is NMED's Exhibit 4, Mr. Secretary?
Exhibit 4 is administrative compliance order to Santa Teresa Water System dated December 17th, 2009.
And is NMED's Exhibit 4 a true and correct copy of the administrative of the ACO issued to the Santa Teresa Water System?
Yes.
Madam Hearing Officer, I would now like to introduce NMED's Exhibit 4 into evidence in this matter.
An objection?
Same 2 prior objections.
Okay, those are overruled. Exhibit 4 is admitted.
Madam Hearing Officer, I have a real quick question. Did you want us to be putting these exhibits up on the screen as we go? Or is it fine that you and the witness have it in front of you?
Unless you're going to engage in a lengthy exploration of a particular document where it'd be helpful to put it on the screen. I have it in front of me. I think the folks who need to have it in front of them.
Thank you, Madam Hearing Officer. Deputy Secretary, what was the ACO marked as NMED's Exhibit 4 regarding?
Exceedance of the arsenic standard.
And is the Santa Teresa Water System still a standalone drinking water system as it was in 2009?
No, it is incorporated into what's now CRRUA.
Okay, one more, Mr. Secretary. Can you please turn to what has been marked as NMED's Exhibit 5? Have you received NMED's Exhibit 5 prior to testifying here today?
Yes.
Are you familiar with the document that is marked as NMED's Exhibit 5?
Yes.
Are you also familiar with the contents of NMED's Exhibit 5?
Yes.
What is NMED's Exhibit 5, Mr. Secretary?
Exhibit 5 is an administrative compliance order to the Sunland Park Water System dated May 27th, 2008.
Is NMED's Exhibit 5 a true and correct copy of the ACO issued to the Sunland Park Water System?
Yes.
Madam Hearing Officer, I would now like to introduce NMED's Exhibit 5 as evidence in this matter.
Objection?
Same 2 prior objections.
Those are overruled. Exhibit 5 is admitted.
Mr. Secretary, what was the ACO marked as NMED's Exhibit 5 regarding?
Exceedance of the arsenic standard.
Is the Sunland Park Water System still a standalone drinking water system as it was in 2009?
No, it is incorporated into the CRRUA system.
Thank you, Mr. Secretary. In addition to those ACOs issued to the individual water systems before the formation of CRRUA, do you know of any other enforcement actions against CRRUA aside from the one we are here to discuss today?
My knowledge, those are the primary enforcement actions. There have been several notices of violation which come before an administrative compliance order for various things.
Mr. Secretary, was there a administrative compliance order conducted by your office, not conducted, issued by your office to CRRUA in 2016?
That's correct. My apologies to that.
Mr. Deputy Secretary, do you recall the violations at issue in the 2016 ACO?
I believe the violations again in 2016 were associated with exceedance of the arsenic standards, among others.
Thank you, Mr. Secretary. In the past, as you've described, you've issued notices, warnings, administrative compliance orders, but then CRRUA tends to fall out of compliance. Is that correct?
That is the history.
Can you elaborate on that a little bit?
Certainly. So there has been a history of identifying issues at CRRUA that need to be corrected that are in violation of the safe drinking water regulations. Some of those through sanitary surveys that identify things that have to be corrected. Some of those in response to complaints. In those cases, CRRUA has, for the most part, made corrections to those items, but they then fall back out of compliance over a period of time, quite often for the very same violations, which indicates an unacceptable process going on. There's an obligation on the part of public water systems to provide safe drinking water that meet all the standards 365 days a year, 24 hours a day. That is the responsibility they take on as a public water system, and the continuous falling out of compliance, coming back into compliance, creates a situation where the public can't trust what's going on with the water and is not an indicator of appropriate management and operation of the system.
Mr. Secretary, what has prompted the enforcement action, including the assessment of civil penalties that we're here discussing today?
Well, as I said earlier, we responded to a complaint, and during the investigation of that complaint, identified that the arsenic treatment systems that CRRUA is required to run to provide safe drinking water to their customers had in fact been turned off. The second thing that we confirmed was that they had not notified their customers, nor had they notified NMED, their regulator, of the fact that this situation was going on, both of which they're required to do. That in and of itself takes this to a level of egregiousness that eclipses many things. CRRUA was not unaware that they had the arsenic systems turned off. They were also not unaware of the fact that there was a requirement to notify the public and to notify NMED. That makes it an intentional act.
Thank you, Mr. Secretary. Is this type of intentional bypass and failure to notify both NMED and its consumers egregious in your mind?
It is egregious.
Can you expand on that?
Well, you have a situation where the public health is without question being impacted by elevated arsenic levels, and failure to notify the customers.
Objection, lack of foundation.
Ms. Grant,
Madam Secretary, Madam Hearing Officer, as the Deputy Secretary has just testified, he served as the head of the Drinking Water Bureau for 16 years and has been the Deputy Secretary for the last 2 years. I think he is very well versed in arsenic and its impacts on consumers.
all right, you might just want to flesh that out a little bit.
Thank you, Madam Hearing Officer. Mr. Secretary, in your tenure with NMED, have you run into arsenic treatment problems with any water utility systems?
We have run into that.
And what is your experience with are you familiar with the compound known as arsenic?
Yes.
And are you familiar with the possible effects that arsenic has on consumers in your experience as the Drinking Water Bureau chief as well as deputy secretary of the environment department.
Let me correct your statement slightly first. I was the Water Protection Division Director, not the
Sorry.
Bureau Chief.
Oh, sorry. I'm sorry, Mr. Secretary.
But with regard to the effects of arsenic, it is well documented the effects that arsenic can have when it's consumed. Everything from birth defects to cancer to organ failure. That is the reason that US EPA set arsenic contamination levels not to be exceeded to protect the public health. And it's those levels that we utilize in the regulatory scheme.
I'm going to object again to the line of questioning. This witness hasn't been entered as an expert witness in public health. The Deputy Cabinet Secretary of the Environment Department is a specific position with specific roles and responsibilities, but I don't think this witness is qualified to testify to public health effects on a scientific level.
All right. If Ms. Real, you'd like to provide more of Mr. Roderick's background. I don't remember if his resume was in here. You could explore that a little bit with him.
Deputy Secretary Roderick, can you tell us a little bit about your education?
Certainly. I have a bachelor's degree from New Mexico State University. It is Bachelor of Applied Studies, which is a hybrid program, specifically directed towards public health, as well as business. I will state for the record that I don't consider myself to be a public health expert. What I am able to say, though, is I am an expert with regard to the requirements to comply with regulations. And the issue here is that CRRUA exceeded the established level of 10 parts per billion, which is established by US EPA. And it's determined not just the number picked out of the air, but it was established by their scientific experts many years ago. It's been in place for a long time.
Let me ask it this way, Mr. Secretary. Are you familiar with the reason why EPA decided to regulate arsenic? Is it because it's good for you? It's bad for you?
I am. It is regulated because it is a risk, a threat to public health. If it exceeds those allowances, then it is consumed.
Thank you, Mr. Secretary.
Object again. I don't think this witness is demonstrated qualified to make that statement.
All right, so that objection is overruled, and you will have a chance to cross-examine Mr. Roderick at some point. Go ahead, Mr. Real.
I'm going to go back to my question, Mr. Secretary. How egregious? Let me ask it this way. Once arsenic's in your system, does it go away?
Objection.
Let me ask it this way. According to any training you've had or any EPA regulations you've read, is arsenic what's termed a forever chemical?
Objection.
Let me ask you, Mr. Real, do you have another witness?
I do, Your Honor. I'll skip over this.
All right, thank you.
Mr. Secretary, is the reason that both EPA and NMED have regulated arsenic and are trying to keep it below a certain level because it impacts the consumers that utilize it?
That's correct.
Object again. I mean, I think that this line of questioning again is not qualified to testify. He stated, "I'm an expert with requirement to comply with regulation." I mean, I think we're going far afield of what this witness's stated qualifications are.
Okay, so Mr. Secretary, is arsenic, as you've stated, is regulated for a reason, correct?
Yes.
Okay, so if someone exceeds the regulated level, the MCL, does it impact the people that utilize it?
I'm going to object again. I mean, I think if he says he has a witness who can testify to the scientific effects, I think he's probably asked that witness instead of the witness who's requirements to comply with regulations.
Right. So, Mr. Real, if you would continue walking that line, please.
Okay.
If you have another witness who can address the uh, impact on the body.
All right, let's just talk about your role as a regulator, Mr. Secretary. A simple question. How egregious is it to intentionally bypass your arsenic treatment system and not notify NMED or the consumers?
The intentional bypass of the system without warning the consumers of what was going on with the water coming out of their taps and without letting the regulator know, intentionally put those consumers at risk. And that risk varies consumer to consumer based on underlying health conditions and things of that nature. But the fact of the matter is, there was an intentional act to not comply with the regulations and an intentional act not to notify the public or the regulator that this was going on.
Has that impacted your trust with CRRUA?
Objection, relevance.
I don't see how that's relevant, Madam Hearing Officer.
His
He's the
personal
Deputy
opinion.
Secretary of the Environment Department. Whether or not he and his department trust CRRUA and its operators is relevant to whether or not the penalty should be both assessed and enhanced.
Mr. Trujillo?
Yeah, asking a witness for their personal opinion, I think, is irrelevant unless it's going to be framed or stated as that this is an official opinion of the department.
Yeah,
Okay.
trust is an unusual word here, Mr. Real. Just rephrase the question, perhaps.
Okay. Mr. Secretary, have you heard any complaints yourself, or has your department heard any complaints about whether or not CRRUA's consumers have a trust issue with CRRUA?
I'm going to object again to the extent that it relies on hearsay.
All right, the hearsay aspect is overruled. Go ahead, Mr. Real.
Would you like me to repeat the question, Mr. Secretary, or do you remember?
No, I have personally participated in community meetings down in Sunland Park with the consumers of CRRUA. I have personally been to their homes in Sunland Park and spoken with them. And one of the things that was very loud and clear was expressed adamantly by those consumers was that they don't have any trust in CRRUA. And in fact, the trust in NMED is eroded because of the fact that they have not been told the truth. They've not been informed of the hazards. There is no trust, which has complicated this significantly.
That leads me to another question, Mr. Secretary. And I think this is a question you may hear from CRRUA on cross-examination, so let me get it out of the way here. Why did your department wait until now to bring this level of an enforcement action for these repeated violations related to arsenic?
The fact that there was an intentional shutdown of a critical component of the system and a failure to notify, to protect the public, make them aware so that they could make an informed decision whether to consume the water or not, and the intentional act of not reporting that to us takes this to an entirely different level. To the extent that we also, in working with CRRUA on this and moving forward with this complaint, required a comprehensive performance evaluation to be done. That evaluation looks at everything from the day-to-day operations of the system all the way through maintenance, through the accounting process, through the management process, looking for the root cause, trying to determine why CRRUA cannot get in compliance and stay in compliance. That is something that we have required of other systems because of the fact that there was so little trust in the customers. We elected to bring in a third-party consulting firm to perform that comprehensive performance evaluation with the agreement of CRRUA, so that it was not, the public couldn't say, well, CRRUA hired the contractor or NMED hired the contractor. We did, in fact, pay for it, but we wanted this third-party evaluation so that it would be impartial and so that we could move forward with permanent corrections, permanent modifications permanent results to ensure that the customers get safe water all the time.
Thank you, Mr. Secretary. Would you say that prior to this enforcement action and maybe even under prior administrations, NMED took a more lenient approach with CRRUA and with all water systems in general?
I would say some prior administrations have favored what I will call compliance assistance, working with the system to try and get them into compliance voluntarily, as evidenced by the fact that we're here today. That hasn't worked. And we have seen that it hasn't worked with many systems. This is not the only operation, not the only administrative compliance order that we have issued in the last couple of years with regard to water and wastewater systems, because the approach has to change.
So what is the current approach with this administration as far as these water systems that are out of compliance?
The current approach is to regulate and enforce to the full extent of our authority in every situation, to evaluate, the level of non-compliance, the egregiousness of the situation. We do look at the history, why things haven't come into compliance, why systems have not, even when they've been notified of non-compliance, taking the actions to move forward. And so we have elevated our enforcement activity across the board.
Can you give us a couple of other examples?
We have, within the last 12 months, issued an administrative compliance order to the city of Santa Fe. The amount of that was around $1 million. We've issued compliance orders to the city of Las Vegas, city of Chama. There's a couple of others that are in the works.
And would you say that the civil penalties that have been assessed since recently under this administration, would you say that there's a difference between how you did it before?
I think the difference is that staff have been directed within the different bureaus to be more aggressive in enforcement, to step out of the let's make a deal role, if you will, and require real compliance.
Did you try the let's make a deal role or what did you refer to before, the voluntary compliance assistance method with CRRUA?
I believe that has been ongoing for the history of CRRUA, and in fact has continued through today.
Mr. Al, we're going to need a break soon. Just find a good stopping point.
This is a good stopping point. I'm halfway through with Mr. Deputy Secretary Rotary.
All right, thank you. Let's come back at 11, please.